Thank you very much, everyone, for your time in watching this webinar that I'm delivering with Jonathan this morning. So although I purport to be Justin Luckman, according to this webinar account, that is not my name, as you may know. My name is Gavin McLeod, and I, along with Jonathan Gale, his name is correct on the strapline of his Zoom window. We are both real estate barristers at St Philip's Chambers. We're talking this morning about two different topics, although there is a broad relationship between them. I'm talking about the question of whether or not, and the principles that govern this question, damages might be awarded in lieu of an injunction. And Jonathan is going to talk about questions regarding cynical breaches of restrictive covenants and how that may impact upon the remedy available to the claimant in cases of that kind. So in very typical 2020-2021 fashion, I'm going to attempt to share a screen with some PowerPoint slides, and that will be as follows, I hope, because I'm going first. Now, I assume, because it says that you are screen sharing, that this is visible on everybody's screen. Perhaps Jonathan would just nod to indicate that's the case.
This is on mine, yes.
Yes, thank you very much. So yes, the question of injunctions or damages instead of them, and the court's discretion to award damages instead of an injunction. Right, so if I play the show, then you won't necessarily get the strap line with all of the slides at the edge. So there we are.
That looks perfect.
Thank you very much. Right, very simply, when does this question arise in the first place? When might there be an injunction which instead of which damages might be awarded? Well, as will be well known, we're talking in the property context, the real property context anyway. Of course, the question arises in other disciplines too, but in terms of the torts of trespass and nuisance, and also as regards breaches of covenant, the like of which Jonathan will be talking about in a moment. General point to note there is that unless you're talking about the parties to the original covenant bound by their common law obligation, a breach of restrictive covenant is an equitable cause of action, whereas the other two aforementioned are common law causes of action. And as we all remember from undergraduate days, the basic and elementary point is that common law damages might be an inadequate remedy, and good old equity, knight in shining armour, can come along and provide in its discretion a remedy of injunction instead. So the question here is, that being so, and when there is, according to authority I will refer to shortly, a so-called prima facie right or entitlement to an injunction, as is true of all three of those instances of wrongs, and is a point reinforced, in fact, in terms of restrictive covenant breaches in any event, where an injunction is said to be the ordinary remedy. What then would be the situation when, instead of this prima facie or indeed ordinary remedy, in equity, damages would be awarded instead? So the jurisdiction for this opportunity for the court to award damages instead goes back to, I think I've got that year right, the Chancery Amendment Act of 1858, which has come to be known ever since as Lord Cairns's Act, after the judicial figure who was responsible for instigating it. It is now incorporated into the Senior Courts Act 1981, section 50. And one point to note, albeit that it's a passing consideration for present purposes, is that the court may award damages either in addition to or instead of an injunction. For present purposes, as the title of this talk implies, I'm focusing on the latter of those, but just for information, it should be noted that the former, in addition to an injunction, would enable equity to provide financial course for instances of past wrongs in addition to the injunction that would restrain the future ones, whereas the latter course that I'm concerned with is an alternative form of compensation for future wrongs, i.e. because the injunction has been refused. Is this a case simply of going through law reports and finding out the answer to when damages will be granted under what is still, even now, styled conventionally as Lord Cairns's Act, or is there another answer to that point? The answer is that precedent is only indicative in cases of this kind in terms of understanding when, instead of an injunction, damages might be awarded. Lord Neuberger said in the Coventry case, also known as Fen Tigers, which many of you will come across in one way, shape or form over the years, that this question is a classic exercise of discretion, which should not as a matter of principle be fettered. He also referred with approval to the below quotation, which is taken from the authoritative judgment of Lord Justice Millett in the 1995 case of Jaggard and Sawyer, whereby Lord Justice Millett indicated that because we're talking about an exercise of discretion in terms of whether there's an injunction and indeed for present purposes whether damages should lie instead of that injunction, previous cases are not binding authorities for the exercise of the discretion. The most that any of them can demonstrate is that in similar circumstances it would not be wrong to exercise the discretion in that way. So necessarily what follows is merely indicative and not demonstrative of the general inquiry, because precedent cannot provide a demonstration of the answer to the general inquiry. One sort of underlying question in terms of jurisdiction is, because it is said to be damages instead of an injunction or in lieu of one, is it necessary to show that an injunction would have been granted otherwise, apart from the considerations which lead to the court concluding that instead of that, damages should be awarded? I referred a moment ago to Jaggard and Sawyer and the authoritative judgment of Lord Justice Millett, and it's clear from that that it is not necessary that in practice an injunction would have been likely to have been awarded. What is necessary only is that in theory there was the opportunity for the claimant to obtain an injunction having regard to the case that he pleaded. If there was in theory such an opportunity, whether or not it would in practice likely ever have been granted, then the jurisdiction in Lord Cairns's Act arises. And so that gives rise to the conclusion, which is particularly relevant for the forthcoming slides, that actually in many cases in which an injunction would never have been granted in reality, that is precisely such a case in which it might well be that damages would be awarded, notwithstanding that perhaps counterintuitively the expression damages in lieu might be taken to suggest that an injunction would always have been likely or even possible. So the sorts of considerations which might prevent an injunction being granted are those whereby the defendant will have equitable defences, such as late cheese or acquiescence. Now, whether these exist are in the judgment of the court. At the risk of oversimplification, I've attempted to paraphrase the distinction between them as comes out of the cases. Late cheese is a concept that is equivalent to an equitable form of limitation, which is to say that the delay before the action has been brought has been so long that in some way, shape or form, it would now be inequitable for the court to enforce, normally because of its effect upon the prospective defendant. Acquiescence, by contrast, is an overlapping but slightly different concept of where the claimant has so acted as to give the defendant the impression that what has become the disputed conduct was actually being accepted and put up with. Those, as I say, are equitable defences which might bar equitable relief. But the question of what is late cheese and what is acquiescence are in a sense relative considerations in the discretion of the court in the court's judgment. If they are considered, or one or other of them as the case may be, is considered to be extreme enough, then all equitable relief will be barred. But in reflection of the point that I've just made, if not, then they may be enough to stop the injunction, but will therefore provide the court with an opportunity to award damages instead of the injunction which the late cheese or acquiescence has been sufficient to stop. So that notion of relativity of late cheese or acquiescence is important. So the point that I've just made, delay and acquiescence may exist, but not to a degree rendering all equitable enforcement unconscionable. In such cases, there likely would be damages under what is now Section 50. There's an example there, the Harris case from 2005. Very simple facts in general terms. Unlawful building, breach of covenant, no intervention when it took place, nothing done for many years, and no injunction was granted when it finally became an issue in proceedings because of this delay and the fact that nothing was done about it timorously. But the court did not consider that the claimant's delay, even after some many years, was such as to make his enforcement of any equitable right unconscionable, and therefore the statutory damages were awarded instead. Pleadings. There is no requirement to plead for an injunction, or at least that is the better view, if you only want damages or indeed only seek damages. There is some doubts about that expressed over to in the Supreme Court in the case of Morris Garner in 2018, but I would suggest that in light of the overall picture, the general principle that you don't need to plead for an injunction if you only want damages or only think you would ever get them has been amended or changed by that doubt expressed by Lord Reed. Conversely, there is no requirement to plead an entitlement to damages in the alternative if you would want an injunction but would put up with damages, or indeed you might have to put up with damages if the court decides that's all you should have. On the other hand, the defendant who would seek that the claimant be limited to damages rather than have an injunction should say so. He should say so before witness statements, at the latest really, and in practice should probably plead that point. That was what Lord Neuberger said in Coventry, amongst many other things, because the point is that the claimant may well have directly relevant evidence to the question of the court's discretion, including having regard to the factors live in the subject matter that we're talking about. And if the defendant does not demonstrate until too late that, or put forward that he is thinking that the claimant should be limited to damages, then the claimant might be unfairly disadvantaged by the defendant's conduct in that respect. So, examples, reiterating the point about how this is entirely illustrative, and no more than that. As already indicated, including by reference to the Harris case, 2005, delay or late cheese and or acquiescence, these broad notions of equitable defence, but when they are insufficient in their operation in a particular case to bar all equitable relief. As probably won't come as any great surprise, when, notwithstanding the prima facie right to an injunction, the harm is trivial or the breach is trivial in its effect. That may well be when damages might be awarded instead. If the claimant has consciously or by his conduct indicated that he only wants money, then the court may well limit him to money. Where the claimant has misconducted himself in some way such that it would be unfair for him to have the restraint of the disputed conduct by an injunction for prospective purposes, or other factors that we will consider. But one point to note is that even if the harm is trivial, if a defendant who has ridden roughshod, as it is sometimes said, over the claimant's rights may well find himself subject to an injunction, notwithstanding the modest nature of his wrong, all coming out of the Shelfer case, which I'll come back to in a minute. Other examples where the claimant did not seek an interim injunction to restrain building which was in breach of covenant, a point that was live in the Harris case and is often live in terms of this question of whether the so-called ordinary remedy of an injunction for breach of a restrictive covenant should not be granted. Where the one example, interesting perhaps, from Small and Oliver and Saunders, 2006, where the covenant's relevance was unclear, at least at the time. There was discussion before building between the parties, but the later claimant did not sufficiently or with due particularity point out what his objections to the prospective or intended building were in terms of the covenant that was afterwards relied upon. And in that case, Small, damages were awarded instead of the injunction because of those factors. In Snell and Prideaux in 1995, the inhibited right of way, which would have led to an injunction apart from the right to grant damages instead, was of, or rather the inhibition of that right of way, was of a form of use which, albeit not abandoned in the legal sense, nevertheless had not in practice been exercised for decades. And so whilst there was a wrong, it was thought that the wrong, in terms of being remedied, should be one for which damages only should be granted. I referred to Coventry or Fen Tigers and to Lord Neuberger's judgment in that case. I think I've referred to that once or twice already. A leading case, and his judgment in particular, repays careful consideration. I've already said, so this is 2013, his judgment, and we're talking about the law in many ways as it has been understood since. I've already said that an injunction is the prima facie remedy for, as it was in that case, instance of nuisance, and indeed for the other wrongs that I've referred to as well. But one point that comes out particularly out of Lord Neuberger's decision in Coventry is that there is absolutely not a test of exceptionality before only damages will be awarded, which had been thought to be the position having in mind Court of Appeal authority before then. If we are talking about this very issue in any given case, Lord Neuberger tells us that there should be no inclination as to what the answer should be right away, either way, subject to the fact that there is the prima facie entitlement. But apart from that, there shouldn't be a particular inclination or predisposition to either outcome. There is something called the Shelfer guidelines based on the Shelfer case I've already referred to, which I'll come to in a moment. And he said, as regards those guidelines, that there is no requirement to go through them, and indeed they should not be gone through formulaically. That said, if one were to do so, go through the Shelfer guidelines, to which I shall return, and if the conclusion were that all of them were met, then he considered that damages would, absent other considerations, likely be the remedy granted. But, and this is perhaps the more important point, he emphasised that Shelfer is not prescriptive, and therefore, if the guidelines or the limbs of Shelfer are not met, it does not follow from that that there will be an injunction, which perhaps had been the understanding before the Coventry case, and he probably had been. Carrying on with those principles, he notes interestingly that public interest may well be relevant, including wider economic consequences of granting an injunction. And the grant of planning permission as regards disputed building may well provide, as he put it, strong support for public interest arguments that would limit the claimant to damages. In a later case in 2017, on this point, Mrs. Justice Slade observed at paragraph 69 how the exercise of discretion in the court may lead to damages only where a homeowner wants peace and quiet to restrict building of a housing estate on neighbouring land over which he has a restrictive covenant. In other words, because of the public interest considerations in the apparent right of the claimant to restrict something which would be of much wider utility by means of an injunction. And what comes out of Lord Neuberger's judgment is that in a case like that, one might well expect that damages only would be awarded. I've referred to Shelfer and these guidelines from the 1895 case. The guidelines, or so-called ready guide or useful indication, or it's been described in many other ways, comprises of these four sublimbs, which lead to the conclusion, or led to the conclusion, that damages would be typical where there was a small injury capable of monetary estimation, which can be compensated by a small money payment. And what small means is very much a relative concept, as we're reminded by the Rogers case I've just noted. And in particular, where it would be oppressive to grant an injunction. And that latter sublim has been considered for many years to be the overarching guide, as it were, to whether or not damages instead of an injunction should be granted. And I've already said about what Lord Neuberger had to say about formulaic reading of these Shelfer guidelines and how that is simply not possible anymore, despite the fact that that was the conventional practice for probably the best part of 100 years, or certainly for significant periods at that time. That said, Even Lord Justice A.L. Smith back in Shelfer in 1895, who said this and laid down this ready guide or useful test, etc., he did caveat what he said by saying that cases where there had been trickery by the defendant, such as trying to build very quickly and secretively, or where the defendant had shown so-called reckless disregard, a phrase I have already used, for the claimant's rights and so on. These cases of inappropriate conduct by the defendant were such he considered, even in 1895, as to make an injunction more likely than damages, even if the test he laid out were otherwise met. So what can we say after Coventry about how things are going, bearing in mind the Shelfer guidelines and Lord Neuberger's insistence that there was not to be a formulaic reading of them? Well, it would appear in practice that probably because I suspect of Lord Neuberger's acknowledgement that if the 4 Shelfer guidelines were met in any given case, then absent other considerations, then damages would fall typically to be awarded. And in light of his recognition of that, perhaps, notwithstanding his reluctance to endorse any form of, and indeed total rejection of, any sort of formulaic or mechanical reading of the Shelfer guidelines, and other judges such as Lord Sumption went even further and referred to them as slavishly out of date. Yet nevertheless, his concession in that regard, I think, has led in practice, probably on account of familiarity with them, to courts deciding that they're going to have them as the starting point in their analysis anyway. And so therefore the Shelfer guidelines have most certainly not been jettisoned in practice. And so that is to say the Shelfer guidelines as a whole, including the caveats that Lord Justice A.L. Smith laid down himself that I've already referred to. And so therefore, where they exist, those considerations are very much likely to point against damages and to an injunction, and even in cases of modest harm. So in the Rogers case that I've already spoken about, amongst other considerations, was that the defendant had said to have conducted himself reprehensibly, and so he was injuncted. In Ottercroft, only a minor right of light infringement, but nevertheless, the defendant had breached undertakings, and it would only cost him about £6,000 to undo the disputed works. An injunction was granted. And one point that perhaps might be taken is that there is, notwithstanding that there clearly hasn't been any sort of radical departure from pre-established understandings after Coventry in terms of the outcome of reported cases in any event, at least some indications exist that there is a recognition now that circumstances are such that damages would be awarded instead of an injunction in a wider array of circumstances than was before the case. And this is perhaps implicit in what was said, amongst perhaps other things, by Mr. Justice Roth in this Brothers Enterprises case of 2017. Now, this was an interim injunction case, so the question of damages was arose in the question of undertakings, etc., rather than a final injunction case of the type that we have been discussing throughout this talk. Nevertheless, he was guided in terms of his conclusion by Lord Neuberger's decision in Coventry and in terms of the applicability or otherwise of the Shelfer guidelines and other considerations to his decision. And he said, and in the quoted passage you will see there that the essence of what the dispute was about, that in the case of an old building used as a hotel, it must be understood that at some point it will need certain building works to be done to uphold and maintain and repair it, and that those may well require temporary interferences with, in this case, rights of way over the premises of a neighbouring restaurant. If that interference cannot be carried out, he noted, those works would be liable to be seriously hampered, even if not, and quite possibly rather, precluded altogether. And so he considered in that case that it would be oppressive in terms of the 4th Shelfer guideline for the defendant to be subject to an injunction. But he also said, and perhaps this is the indication of how things may change, and there's a recognition that there's the potential for things to change, but pursuant to Coventry, that bearing in mind Lord Neuberger's observation that the Shelford guidelines should not be strictly applied, he was prepared to say that this was a case where even if it wouldn't have been oppressive to grant an injunction, the claimant should be limited to damages anyway. Or rather, an injunction should be refused, and therefore we could perhaps take, in the context of a final injunction, because that was an interim injunction, as I've already said, we could perhaps take from that if it were a case of a final injunction, he was indicating that it would be a case where perhaps damages would be the award given in any event. So no massive revolutionary changes since Coventry by any stretch, but perhaps indications of a recognition of what Lord Neuberger was saying, that in a wider array of circumstances now one might suppose that damages would be considered the appropriate remedy rather than an injunction. And on that note, I think that I will be in a position to stop. I will stop sharing and I will hand over to Jonathan for his talk. Thank you very much indeed.
Thank you very much, Gavin. If you'll just bear with me while I get the screen. Good morning. I'm going to talk about this case, Alexander Devine Children's Cancer Trusts and Housing Solutions Limited, which was a recent Supreme Court case. It's the first time Section 84 of the Law of Property Act 1925 has been considered by the Supreme Court, the House of Lords for that matter. In a judgment handed down in November 2020 by Lord Burrows, with which Lords Kerr, Lloyd-Jones, Kitchen and Hamblin agreed, the Supreme Court upheld the Court of Appeal's decision to overturn the discharge by the Upper Tribunal Property Chamber of a restrictive covenant. Restrictive covenants can bind land forever. They affect parties who never agreed directly with each other to be bound by them. They prevent people from using their property as they see fit, and they give private landowners power over their neighbours. One might take the view that control of neighbourhoods ought to be done more by the more developed planning law now, which is developed separately. But nonetheless, restrictive covenants are well established. This is on the slide is a passage from a legal text, which was cited in the Supreme Court. Restrictive covenants place a long-term fetter upon the affected land, but in some cases it's clearly undesirable that the inhibition upon land should continue indefinitely. There may arise changes of circumstance where it becomes preferable, in the interests of general social utility, that the constraints imposed by a particular covenant should be abrogated or modified. And that's the function of Section 84 of the Law of Property Act 1925. The Upper Tribunal has the power, i.e. the discretion, to discharge or modify any such restrictive covenant on freehold land, and also in the case of some long leases as well. It has the discretion to do this, but only if it's satisfied with the existence of one or more of 5 grounds. 5 grounds being that the covenant or restriction is obsolete, in that the original purpose of the covenant can no longer be served, that it impedes reasonable user and is of no practical benefit, or is contrary to the public interest. And those are 2 grounds, 2 separate grounds, and discharge can be compensated in that respect, which leads to an analogy with damages in lieu of an injunction, which we'll come to later, and that was touched on by the Upper Tribunal and the Court of Appeal in this Alexander Devine case. The other 2 grounds, agreement between the parties and that there be no injury to the benefited party. Compensation can be awarded, and that is under either of 2 heads: a sum to make up for any loss or disadvantage suffered by the beneficiary in consequence of the discharge or modification, or alternatively, a sum to make up for any effect which the restriction had at the time when it was imposed in reducing the consideration then received for the land affected by it. One or other of those 2 heads. It's not supposed to be compensation for a loss of bargaining, but that of course may be influenced in the calculation under the first head, a sum to make up for any loss or disadvantage suffered. in consequence of the discharge or modification. The ground to which this case, Alexander Devine, relates is the third ground, that the restrictive covenant impedes reasonable user contrary to the public interest. Millgate Developments Limited was a property developer of housing. It had land upon which was registered the following restrictive covenant: no building, structure, or other erection of whatsoever nature shall be built, erected, or placed on the application land, and the land shall not be used for any purposes whatsoever other than as an open space for the parking of motor vehicles. Clearly, it's a very ordinary standard restrictive covenant that one is likely to see. A property developer may look at that restrictive covenant and just be tempted to start building and hope that no one objects. Don't trouble till trouble troubles you. One may risk opening a can of worms by looking for beneficiaries and trying to negotiate with them. There may be a commercial argument in some circumstances for just starting and taking the risk, but it is a risk. Millgate took that risk. They applied for planning permission and got it for 13 units of affordable housing on the site for tenants who've been waiting for properties, in some cases for many years. Starting building in deliberate breach of a covenant is known as a cynical breach. The term has moralistic overtones, but its shorthand was clarified by the Supreme Court as deliberately committing a breach of the restrictive covenant with a view to a profit. Millgate made no effort to find out who had the benefit of the covenant. They breached the covenants without justification or excuse, and they were found to have attempted to steal a march on the trust, the beneficiary owner, who at the time, early on, were not aware of the covenant. And they failed to make the Section 84 application before building. So they already looked bad. To make them look even worse, I suppose, one could take the view, the beneficiary was the Alexander Devine Children's Cancer Hospice. So there we have a land use conflict. Children living peacefully on land which was privately and secluded versus the much needed affordable housing. There were tenants who'd been waiting many years for a place to live, and planning permission had been granted even though it was against the local plan, in recognition by the local authority of the need for social housing. Millgate applied to the upper tribunal under Section 84 to have the covenant discharged. The ground they relied upon was reasonable user in the public interest. For an application to succeed on the grounds of public interest, it's necessary to show that the interest is so important and immediate as to justify the serious interference with private rights and the sanctity of contract. So the sanctity of contract, again, shows that the law travels into vaguely moralistic approach to contractual rights where property is concerned, at least. The upper tribunal were conscious of the cynical breach. They recognized that Millgate had acted in a high-handed manner, but in its discretion, the tribunal concluded that their decision would have an effect not only on the parties, but also on 13 families or individuals who are waiting to be housed in these properties, if and as soon as the restrictions are modified. We consider that the public interest outweighs all other factors in this case. It would indeed be an unconscionable waste of resources for those houses to continue to remain empty. The trust appealed and the Court of Appeal disagreed. In fact, the Court of Appeal held that the ground was not made out. Lord Justice Sales, as he then was, said there was a public interest in having private contractual and property rights respected in dealings between private persons. They noted the high-handed manner in which Millgate had just begun building without any justification or excuse. They noted that they'd attempted to steal a march on the trust, and it was said that Millgate had sought to evade the jurisdiction of the upper tribunal at the appropriate stage. And at the appropriate course, having regard for the need for due protection of the trust rights and the public interest in having the Section 84 procedure invoked at the proper time and in the proper manner, would have been to exercise its discretion to refuse Millgate's application, thus overturning the upper tribunal decision and refusing to discharge the covenant. The Supreme Court took a different approach when Millgate appealed. And the Supreme Court, in fact, held that the ground had, in fact, been made out of public interest. And that public interest, the question of whether the covenant impedes reasonable user contrary to the public interest, is a narrow question. It's not a question of whether it's in the public interest to discharge the covenant or what is in the public interest. The question is it against the public interest to impede this user which is reasonable? And the Supreme Court could not fault the tribunal's ruling on that originally. Then looking at the matter of conduct, that was separated from the matter of discretion, or the matter of conduct was to be considered at the discretion stage and is irrelevant to any of the 5 grounds. Then turning to the Court of Appeal's decision on the tribunal's discretion, it was noted that Lord Justice Sales said that the upper tribunal failed to attach sufficient weight to the cynical conduct of Millgate. Now, in an interference with the exercise of discretion, the failure to attach sufficient weight must amount to a matter of principle, an error of principle. But the Supreme Court rejected any principle that a cynical breach should outweigh what would otherwise be the public interest in discharging or modifying a covenant. Nonetheless, in this case, the Supreme Court did overturn the upper tribunal's discretion, despite the difficulty in interfering with such an exercise of discretion, because the upper tribunal had omitted 2 factors from the exercise of its discretion, 2 related factors. And that related to the fact that Millgate could have built the development that it wanted entirely on unencumbered land, avoiding the land use conflict at no cost to themselves and satisfying the demand for housing. For that reason, the Supreme Court thought that had Millgate made the Section 84 application before building, it would probably have been unsuccessful in that event. So the distinction between the Supreme Court and the Court of Appeal's decisions on this were that while the Court of Appeal wanted to punish an applicant for a cynical breach, that wasn't the case with the Supreme Court. Applicants were not punished. The applicant was not punished. It simply was just not allowed to benefit from having made the application late after it had started building. So adopting the Supreme Court's approach, although it is usually advisable to begin a development, not advisable to begin a development in breach of a restrictive covenant, an applicant will not necessarily be punished for doing so. Nonetheless, I would still advise, if possible, making the application before you start building. But the Supreme Court didn't take quite such a punitive attitude as the Court of Appeal. Some interesting things came out of the Court of Appeal decision, even though they are, in the light of the Supreme Court decision, obiter. And that's to do with the relevance of planning permission to the public interest. The upper tribunal was referred to the guidance of Lord Sumption in Lawrence and Fenn Tigers on the consideration of whether damages should be awarded in lieu of an injunction. One can see the analogy in terms of buying rights. Lord Sumption in that case went further than the main judgment which Gavin has already talked about of Lord Neuberger. Lord Sumption thought that the traditional primacy afforded to an injunction was based mainly on the court's objection to sanctioning a wrong by allowing the defendant to pay for the right to go on doing it, which Lord Sumption said seemed an unduly moralistic approach to disputes. And the upper tribunal was encouraged to rely on the relevance of planning permission in the context of buying rights through the discharge of covenants, analogous to paying damages in lieu of injunction on the basis of Lord Sumption's decision. The Court of Appeal disapproved the analogy between that, distinguishing the matters by being a distinction between the tort of nuisance and the more hard-edged and specific private right in the form of a binding restrictive covenant. So it's interesting that in this case we see a distinction not just between an application under Section 84 and a question of whether damages should be awarded in lieu of an injunction, but actually between the underlying causes of action, which does raise the question as to whether the Shelfer principles for damages in lieu of an injunction ought perhaps to be applied differently, depending on whether the underlying cause of action is in nuisance or a more hard-edged and specific right in the form of a binding restrictive covenant. The other interesting question that perhaps was raised was this part of what Lord Justice Salesley then was said, was the distinction between Lord Sumption's guidance and the question at hand was that the guidance was addressed to a stage of analysis distinct from that which arises under Section 84. Even if a restrictive covenant is upheld and maintained in place after examination under Section 84, the question of whether an injunction should be granted remains to be determined in court proceedings which may be brought to enforce the covenant. So in other words, if a cynical applicant has made an application under Section 84 and failed, it still may get another bite of the cherry, given that it's a different question when it comes to awarding an injunction. It may have another opportunity to purchase the rights. So that's the case of the Supreme Court case on an aspect of Section 84, and it's always helpful to have guidance, and that is the first time that the section's been considered at such a high level. Thank you all very much for attending. I'm sorry we can't give you breakfast. Next seminar from St Philip's will be Wednesday the 3rd of March, which will feature Tony Devine on mediation and evaluation in property courts and tribunals, and Raghav Trivedi on proprietary estoppel, updates and practical tips. Thank you very much for coming, and thank you, Gavin.
Thank you, Jonathan. Thank you all.